Hi, this is Dana McLendon, your host for Ready for Trial. Wanted to cover today an issue that comes up a lot. I get a call about this often, and in a mobile society, this is increasingly common. This is the issue of parental relocation. So, in Tennessee, if you get divorced, you will wind up with a parenting plan. If you have children, you will wind up with a parenting plan that has something in it like this. Here at generally towards the end of your parenting plan, it'll say notice regarding parental relocation. And it generally says that if you want to move more than 50 miles from the other parent or out of state, that there's this procedure you have to go to or go through. So it requires basically notice, and then you could wind up having an argument about it. You could wind up having to go see the judge and let the judge decide whether or not the children are going to be allowed to relocate more than 50 miles away from the other parent. So this, in the parenting plan, this establishes the procedure to tell the other parent and begin the process. But once the process begins, then we get into the actual process at the courthouse to resolve the situation, right? So to start the process, you have to send a notice with these four things that you see here: the statement of intent to move, location of proposed residence, the reason for the relocation, and a statement that the other parent basically has 30 days to object by filing something at the courthouse. The parties then have a chance to agree on a new parenting plan, but not many parents are going to agree that the children can be moved that far away from them. That will complicate everything, right? So let's assume a situation where the parties are not able to agree on a new parenting plan that accommodates this move. So what's going to happen next? Well, the court is going to have a trial. And at that trial, the court is going to consider, as you can see here in paragraph 2, what is in the best interest of the minor child or children. All right. That is really always the driving factor in custody cases. What is the best interest of the children? So in making that choice or making that decision, the judge is going to think about a few things that are put here in the statute. One of them is the nature, quality, extent of involvement, and duration of the child's relationship with the parent proposing to relocate and with the non-relocating parent. So basically, how much of a parent have each of you been? Are you kind of aloof and remote and don't do very much with your kid, and now you want to get in the way of a move? Or are you active, involved, and present? The more active, involved, and present you are, the better this factor weighs in your favor if you are the parent opposing the relocation. Same goes for siblings and step-siblings, half-siblings, and grandparents and that kind of thing. B, the age and developmental stage of the child, and the impact that the relocation might have on the child's physical, educational, and emotional development. Are you moving the child to somewhere, or is the proposal to move the child to somewhere that they will suddenly not have much in the way of a support system, that their school will be poor or worse than the one they're at? Are they going to be lacking in services where they're going to live if they're allowed to relocate? Or maybe all those things are going to be provided tenfold beyond what they're currently able to access where they currently live. Court's also going to wonder, well, if the children move, what can we do to keep the relationship between the non-moving parent and the children alive and well? What does that look like? And obviously, the big difference here are they moving 51 miles away, or are they moving what I call far, far away? Like, we're taking a plane to see each other. Those are different scenarios, and obviously much more drastic outcomes. Being able to see your kid by driving an hour is a whole different thing than having to buy a $400 round-trip ticket to see them. I've covered this in another video about the children's preference, but if the child is 12 or older, they get some say here. Now, it's important to remember that judges are not going to turn the decision over to a 12-year-old or even a 17-year-old. The older a child is, the more impact that their preference might have, but if they're 12, the judge will at least listen. This one is key, and this one is often really what we're litigating in these relocation cases, and that is the parent who's proposing to relocate doing so spitefully? Are they doing so as part of a pattern that they have established to try to drive a wedge between the other parent and the child? This is the parental alienation. If you Google that, you'll find a billion resources, some good, some not so good, about what parental alienation is. But this is the part of the statute that covers that. So if a parent is proposing to relocate and they have a pattern of trying to keep the kid away from the other parent or trying to drive a wedge between the parent and the children, that's going to be brought up under this paragraph. Also, what would life look like under F? What we're driving at here is, what is life going to look like if the child is allowed to relocate? Are they going to be exposed to other people, other family members who are good people who can help them become a good adult? Is the move going to allow the parent who's moving to triple their income and thus provide more resources and access to enrichment for the child? So it's going to matter. The judge will at this point kind of take a look into what a day in the life of the child would look like if the judge allows them to move. The reasons for each parent moving or seeking to move, or the reason you're trying to block it. It's not generally enough to just say, well, I don't want my kid to move. I mean, that's a good reason, but this one really sort of falls on the parent who's trying to move. Like, if you're moving and you want to take your children away from the other parent, you should have a good reason. There should be some opportunity or need that the move addresses. Like, you have a great job opportunity, or you have an education opportunity, or it may be, hey, my family needs me to come back. Mom and dad are old and sick, or something like that. What is the reason that you're planning to move, and why is the other parent trying to block it? And then any other reason affecting the best interest of the child, which include the entire list of custody factors in 36.6.106. I'm not going to cover those now. That's a list of 15 factors. I'll do another video on that. But let's just say that the judge goes through all this and concludes that the parent who's proposing to move has carried the day. At that point, the judge is going to create a new parenting plan that reflects the move. Alternatively, the judge might say, well, I'm not going to let the kids move, but if you want to move, to the parent who wants to move, if you want to move, I'll make a new parenting plan that accommodates the fact that you're moving. So either one of those outcomes is possible. Good news here is that it's a level playing field. It wasn't always a level playing field. It used to be that if you were the parent who had primary custody, that you were presumed to be allowed to move unless the other parent could show something, a short list of things that were nearly impossible to prove. Relocations used to be done you almost couldn't block them at all. I thought that was a horrendous rule. I thought that was tragically unfair to parents and children. I saw it abused more than once. But the legislature has amended it, so it is now a level playing field. At this point, if you want to relocate a child more than 50 miles from the other parent or out of state, you're going to have to be able to convince a judge that it is best for the children that you be allowed to move and take them with you. So that is that's sort of what relocation in Tennessee looks like. If you need to contact me, you can do so. I'll get there in a minute. You can do so at danamclendonlaw.com if you have a relocation case, or if you want to relocate, or if you're looking to block a relocation. I've tried many of those cases. You can reach me there at danamclendonlaw.com. If you like what I'm doing here, please do hit the subscribe button. Follow me on all these social media things that are over here. Listen to my podcast. I'm doing this kind of thing for free and for no reason other than to help people that are out there trying to figure out whether or not they need a lawyer and which one they need to find the right lawyer for them. So I'm Dana McLendon. This is Ready for Trial. Thank you for watching.